The Minnesota House of Representatives Committee on Public Safety and Criminal Justice Reform will come to order. The clerk will take the roll.
Chair Mariani.
Present.
Vice Chair Frazier.
Present.
Representative Johnson.
Present.
Representative Edelson.
Present.
Representative Feist.
Present.
Representative Grossel excused. Representative Hollins.
Present.
Representative Hewitt.
Present.
Representative Cleavorn.
Present.
Representative Long.
Present.
Representative Lucero. Representative Lucero. Representative Mueller.
Present.
Representative Novotny.
Novotny present.
Representative O'Neill.
O'Neill present.
Representative Pinto.
Present.
Representative Poston excused. Representative Raleigh.
Raleigh present.
Representative Vang.
Present.
Representative Xiong. Representative Xiong. Representative Lucero. Representative Xiong. That concludes roll call with 15 present.
Thank you. There is a quorum present. This hearing is being conducted remotely on an electronic platform pursuant to Minnesota House Rule 10.01, which can be viewed on the Minnesota House website. Also on the Minnesota House website, on the committee page, the public can view instructions on how to access this hearing in streaming video, as well as instructions for participating in public testimony. Members, we have 4 bills up today. And our first item of business is to adopt our minutes from our last meeting, which would be March 9th. And I'm wondering, Representative Edelson, if you would be so kind as to move adoption. Or perhaps somebody else on the committee.
I can move it, Mr. Chair.
Very well. Representative
So
Hollins.
moved.
Representative Hollins moves adoption of the minutes from March 9th. Discussion. Representative Johnson, voice vote okay?
Voice vote is fine.
Very well, thank you. All in favor of the motion, please say aye.
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 All same sign. Motion prevails. And the minutes from March 9th of this committee are hereby adopted. Members, as I said, we have 4 bills up. The first one will be House File 1368 that I'm authoring. So the chair moves to refer House File 1368 to the General Register. We've heard this bill in the prior session, although there are members here who were not present at that time. We did have quite extensive testimony on this bill last year. The bill proposes policy changes to the Department of Corrections Fugitive Apprehension Unit, including granting the unit general police powers. And here to speak to the bill is John Melvin, Director of the Office of Special Investigations, and Mark Koderick, Associate Director of Office of Special Investigations. So if I can have you come forward, Mr. Melvin, you first, explain, give us your name, and if you could explain what this bill does and why it's being proposed by the department.
Okay, thank you.
I'm sorry, Mr. Melvin. Mr. Melvin, I do apologize. Let me interrupt. There is an author's amendment which puts us in the shape that the author wishes it to be before us, and I think actually is important in terms of your testimony as well. So the chair will move the A1 amendment to House File 1368. Representative Johnson, are you fine with a voice vote, or do you prefer a roll on this one?
I am fine with a voice vote on this amendment.
Very well. Thank you, Representative Johnson. Members, all in favor of the A1 amendment, please say aye.
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 Opposed, same sign. Motion prevails, and House File 1368 is amended with the A1 amendment. And now, Mr. Melvin, again, my apologies to you. Please come forward, give us your name and testimony.
Absolutely. Thank you, Mr. Chair and members, for the opportunity to testify today in support of House File 1368. For the record, my name is John Melvin. I serve as the Director of the Office of Special Investigations and Fugitive Apprehension Unit. The Minnesota Department of Corrections Fugitive Unit was created by the legislature in 2000 under State Statute 241, which really gave the Commissioner of Corrections the ability and the authority to have fugitive apprehension members perform duties necessary statewide and make statewide arrests. The issue with that is that the authority of the agency is limited to the arrests of DOC, discretionary and statutory release violators, and DOC facility escapees. Currently, right now, our unit is made up of 13 post-certified peace officers who are highly trained in fugitive apprehensions. And we partner with just about everybody, local, county, state, and federal partners almost daily to get this work done. House File 1368 before us today explicitly authorizes the DOC peace officers to carry out general law enforcement duties in coordination with, and I repeat, in coordination with law enforcement agencies of jurisdiction. It also allows for investigation of criminal offenses in agency-operated correctional facilities and surrounding properties to assist other law enforcement agencies upon request. Finally, the bill permits local law enforcement agencies to authorize our officers to assume subsequent investigation of crimes should the primary jurisdiction choose so. With that today, I really would like to have Mark Koderick, my assistant director, really emphasize and provide some examples where community safety is negatively impacted by our current restrictions on our officers' authority.
Well, thank you, Mr. Melvin, and thank you for your upcoming testimony, Mr. Koderick. It's always good as we propose legislation to be able to have real on-the-ground stories that translate them, their impact for us. So please come forward, state your name for the record, give us your testimony.
Thank you, Chair and members, for having me here to speak on House File 1368 and our legislative framework. I am Mark Koderick, the Assistant Director of the Office of Special Investigations and the Fugitive Apprehension Unit for the Department of Corrections. The legal framework envisioned by this bill is similar to the statute used by Metro Transit officers. It grants our officers general law enforcement authority during the course of their duties as defined in statute and while assisting other law enforcement agencies. Currently, as stated by the Director, our unit is unable to assist or provide aid to local law enforcement jurisdictions in keeping our communities safe. There are three considerations relevant to this bill that I'd like to address today. First, this bill proposes that our officers may, on request, assist local law enforcement. By way of example, when we hear that there's a significant activity in the community, such as active shooter, robbery in progress, hostage situations, officers requesting assistance, has happened in that community, we can't currently respond to those calls. This bill allows us to provide aid to local law enforcement to address developing situations if requested. Second, the bill clarifies that our officers have general law enforcement duties. DOC officers are always in the community. And I think that's forgotten because we're just not that large. We're always in the community working to find violators who have absconded from supervision release. For example, if a domestic call were to come in while we're conducting our investigation, even if the DOC officer's response time would result in quicker intervention, we are currently not able to assist the local jurisdiction in this call. DOC officers are only licensed peace officers limited to a single purpose. Third, this bill makes sure that what happens in our facilities does not put a strain on local resources. When crimes are committed in our facilities, such as violations of order for protection, harassment by a person that's in custody to somebody on the outside, narcotics introduction into our facilities, or assaults in a Minnesota State Correctional Facilities itself, we have to involve local law enforcement, which can become very involved for that law enforcement. This is an impact on the community, and it takes away law enforcement's time from their community. Our officers are in this unique position to exercise law enforcement duties when investigating general cases in a way that can support local jurisdictions, thereby conserving their resources for community members. I'll close by noting that the officers, myself included, come from years of previous experience working as peace officers without restrictions to the statutes and laws taught to us through the licensing process. We come from departments such as Ramsey County Sheriff's Office, Maplewood Police Department, Wright County Sheriff's Office, Mille Lacs Lake Tribal Police, Waseca Police Department, and Hennepin County Sheriff's Office, to name a few. By supporting this legislative change to bring the DOC officers in line with all other law enforcement officers in the state, you are allowing these talented, experienced veteran officers to work and contribute to an overall safer Minnesota community. Thank you, Chair.
Thank you, Mr. Kodrick. And I think you answered the question I had right off the bat, which is, I think looking at this unit, just, as a layperson, I would assume, well, wait a minute, are these officers trained the way that officers are trained and prepared out in local communities? I think what your testimony is that, well, that's exactly how we became officers, and that, in fact, on the ground, what you have is a recruitment where the unit has recruited from within existing peace officers and local jurisdictions. Is that an accurate depiction?
That would be exactly accurate, Mr. Chair. And just so it's clear, we take the same training that every peace officer takes because we have to stay licensed. We just can't enact any of that training unless it's strictly related to a supervision release violator at this time. And I think the youngest person that we've ever hired in our unit since I've been here for the last 5 years has just under 16 years at Edina Police Department before he came here.
All right, very well. And you also testified that there's a parallel with the Metro Transit officers, where obviously Metro Transit officers are hired for Metro Transit. I think your testimony is that they're able to respond in the same manner in which this proposal is before us.
That is correct, Chair. We ended up, we first looked at this back in 2015. We were trying to see if there was statute language that was similar to our unit, and Metro Transit had the most similar language that allows them, while they're in a jurisdiction on the transit lines, if a crime or something's occurring around them, they would still have to work with the local jurisdiction to verify that it's, whether it's a case they wanted to take on or if it's a case that they're directed to take primary responsibility to conduct general law enforcement duties.
All right, thank you. We do have questions from other members. We'll begin with Representative Johnson.
Chair Mariani, in the past, we've had some issues with this bill. The bill today is much better, much more, I think it's much more in lines with what we are thinking, because it's, as the testifiers mentioned, now they can, with this bill, they could actually take care of a lot of the investigations for crimes inside the prisons themselves, which relieves a lot of issues with the local law enforcement. I myself have been in favor of that. It's their buildings, they should be maintaining them. I'm just wondering with the amount of calls that they have in the prison system, because I know there is a number. Are you going to have if you're going to take over that part of it, working with the local law enforcement, are you going to have to hire more staff, more officers to fulfill those responsibilities as well?
Mr. Melvin or Mr. Kodrick, whoever.
Thank you, Chair. I do apologize to step in here in camera view. Currently, and this is one of the unique things about our institutions, and we've reached out to a lot of the chiefs and some of the sheriffs that are jurisdictional. What this jurisdiction wouldn't change, but allow our facilities to investigate, was that we have special investigators that are there currently. So they're civilian counterparts to kind of our apprehension counterparts. And essentially, I apologize, computer just.
We lost you. We
Lost the audio.
the audio. Yeah.
Am I back now, Mr. Chair?
You're back. You're here.
I apologize. Computer went to screensaver mode. So our civilian counterparts in the prisons right now do a lot of the charging through the local contacts in that jurisdiction. We're not, and this is what was presented to the chiefs and the sheriffs there, is we're not looking to take over the sole jurisdictional component. What we're doing is trying to be of more of assistance. Right now, if we have, for instance, narcotics case, and I'll be honest, we do have narcotics introduction in our prisons that we're always trying to catch and solve. We have to allow that local jurisdiction to be the ones that get the subpoenas and the court orders and follow the data trails and the info trails, because we can't. Where this bill would help change that would be that we could then ask that local jurisdiction, can we allow some assistance in that? Can we help you? Can we write these orders? Can we write these subpoenas based on your behalf? And they can say yes. So essentially relieve that and allow that person to be out in the community. Now, it's not going to allow us to hire anybody because, again, that is a budget component. We don't foresee that as a need to hire anybody because those that are in there now as the civilian side are actually packaging up the cases as they are and sending them through those community law enforcement jurisdictions. We could also help reroute that and to help if they were too busy to send the charging paperwork through the e-filing system and allow the county's attorneys to see it just as fast as they could as the civilian side. So we don't see the need to hire more staff at this point. Is there a chance that it could encumber 5-10 years from now? Possibly, but we would need to approach that if that were to be the case through a different legislative means to say, hey, we need to hire somebody. But that's not the perception we have. Really what we're looking at is the simple side of things, the data disclosures, the charging paperwork as it goes through courts instead of switching hands to a different jurisdiction so the BCA files become intact. But we're also trying to ask for information from local jurisdictions, not getting declined that information because we're trying to investigate an internal case that could be a criminal case before it gets referred. And we're not after any stats or anything. So having those talks with those chiefs, they've really been on board with the fact that, are you going to continue the cooperation that you have been in? Yes, 100% yes. We're not looking to solely go off in our own silo. We're looking to work cooperatively just like we did in the past, but just be able to stretch it a little further to help them with that intelligence side of the case through our peace officer licenses instead of just being stuck on the civilian side.
Very well. Representative Johnson.
Okay, I appreciate that. So basically, it's going to somewhat stay the same that it is, where if something happens, it'll still get reported to the local jurisdiction that has oversight over that community. And if you do end up doing the investigation, it'll still be reported and everything will be handled through the local community or the local jurisdiction that has jurisdiction. And that's one thing I want to make sure that stays in place so they have an accurate account of what's going on in their community, because the sheriff or the chief is still responsible for this, technically still responsible for the safety of the people inside those facilities. I do have some concern when you have non-licensed people doing the investigations, because I hope you can understand that as well as a licensed peace officer. That's something we may want to look at, because I know in HHS when they had the private investigators doing the cases in HHS, some counties got into a little bit of trouble how things were done there. So we just want to make sure things are done properly. Thank you.
Thank you, Representative Johnson. Seeing no further inquiries, the chair renews his motion to refer House File 1368 as amended to the General Register. The clerk will take the roll.
Mariani.
Aye.
Chair Mariani, aye. Vice Chair Frazier.
Aye.
Vice Chair Frazier, aye. Representative Johnson.
Johnson, aye.
Representative Johnson, aye. Representative Edelson.
Aye.
Representative Edelson, aye. Representative Feist.
Aye.
Representative Feist, aye. Representative Grossel, excused. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hewitt.
Aye.
Representative Hewitt, aye. Representative Cleavorn.
Aye.
Representative Cleavorn, aye. Representative Long.
Aye.
Representative Long, aye. Representative Lucero.
Yes.
Representative Lucero, aye. Representative Mueller.
Mueller votes yes.
Representative Mueller, aye. Representative Novotny.
Novotny, aye.
Representative Novotny, aye. Representative O'Neill.
O'Neill, aye.
Representative O'Neill, aye. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Poston, excused. Representative Raleigh.
Raleigh, aye.
Representative Raleigh, aye. Representative Vang.
Aye.
Representative Vang, aye. Representative Xiong. Representative Xiong. That concludes roll call with 16 ayes and 0 nays.
Very well, with 16 ayes and 0 nays, the motion prevails. And House File 1368 as amended is referred to the General Registry. Thank you, Director Melvin and Associate Director Kodrick for your presence and your work in this area. Next, members, Representative Frazier, House File 1374, and I believe you have a motion for us.
Yes, Mr. Chair, I would have a motion to, are we laying this over for,
Judiciary.
Like this motion, I would like to refer this bill to judiciary.
Very well. Representative Frazier moves to refer House File 1374 to the Judiciary Committee. Representative Frazier, your bill is before us.
Thank you, Mr. Chair. As many of you are aware, during the July 2020 special session, the legislature passed the Minnesota Police Accountability Act. This act included the creation of a centralized database of officer misconduct data. The data included in the database is currently all public data, meaning you could go down to your local law enforcement agency and make a data request for the data, and the agency would have to give you or should be able to give you that data. The purpose for collecting this data is to require the post board to evaluate the effectiveness of officer training, to assist the Citizens Council in accomplishing its duties, to allow for the council and the complaint investigation committee to identify patterns of behavior that may suggest an officer is likely to violate a model policy. And lastly, the post board is required to submit an annual report to the legislator that includes summary data related to officer misconduct. A copy of this report must be available for the public on the post board's website. House File 1374 expands the current database to include certain private police officer data. As with the public data currently being reported, the chief law enforcement officer will also be required to submit real-time private data. The data classification will not change. The classification will remain private as defined in Chapter 13. The intent in making this change is to capture data that would assist the post board in developing an effective early warning system to identify problem officers. Currently, the public data shared to the post board does not encompass complaints that did not result in formal discipline, because that data is not considered public. Passing House File 1374 into law will provide the post board with the data it needs to effectively develop and ultimately implement the early warning system as was intended when the Police Accountability Act was voted into law in the summer of 2020. Mr. Chair, that concludes my remarks, but I do have two testifiers that I would like to have them provide more insight into why this language is necessary.
Very well. I see that you have Dr. Gina Erickson from Hamlin University, and then Director Eric Missel from the Post Board. So let's begin with Dr. Erickson, if you can come forward and state your name for the record and provide us with your testimony.
Yes, hi. Thank you for having me here today, Mr. Chair and members of the committee. My name is Dr. Gina Erickson. I hold a PhD in sociology and I'm an associate professor in the Department of Criminal Justice and Forensic Science at Hamlin University. I'm here today to speak about the primary need for data on officers in Minnesota. Last summer, my colleagues at Hamlin and I made several recommendations both formally to the post board and publicly in the news media about exactly this kind of data collection. Minnesota was once a pioneer in thinking about law enforcement oversight. However, the last 5 years in Minnesota have brought several unfortunate and high-profile civilian deaths at the hands of police officers. Collecting data earlier and more often is the way we can work toward proactively preventing these kinds of tragedies in the future. Current post-board data shows only a fraction of complaints against officers, based only on reports that are made public. Following the death of Mr. George Floyd, the investigation of his accused killer, former officer Derek Chauvin, brought to light many complaints against him. These complaints live solely within MPD and would not have been brought to light without the investigation following Mr. Floyd's death. And the complaints of use of force by Julian Hernandez, Zoya Cody, Jimmy Bostic, and Sir Riley Pete, among others, would not have been recorded in any coordinated way. And former officer Chauvin would likely have continued to climb the ranks in MPD. This bill expands the current database to include certain kinds of private officer data. This data will remain private and will be reported by the police chiefs to the post board. So far, 31 states have introduced 124 bills to promote this kind of transparency and legislation. As this shows, Minnesota, once a leader in police oversight and regulation in the nation, is now falling significantly behind other states. The current statute does not allow the post board to capture the data necessary to prevent critical incidents of use of force. This bill would be a major step forward in moving this goal. We need data collection of this nature to ensure evidence-based criminal justice practice and policies at all levels and for all persons, and to centrally capture the kind of data necessary for early intervention to prevent civilian lives. Thank you.
Thank you, Dr. Erickson. I hope you can stick around for a bit in case there are questions.
Yes, Mr. Chairman, I will.
Very well, thank you. So next we have Director Missel from the Post Board. Director Missel, welcome to the committee.
Thank you, Mr. Chair, members. My name is Eric Missel. I'm the Executive Director of the Minnesota Post Board. I have a couple of additional comments I would add to the testimony that was already given regarding this legislation primarily from the practical standpoint of what it means, the way it's currently written versus what is proposed. As was pointed out, the way it is currently written, we would not be able to collect the data that we would need to carry out our charge under the statute that was passed, the reform bill essentially that was passed in 2020. I want to emphasize a couple of things. One, that as was mentioned, the collection of this data does not change its classification. It would remain private, even though it would come into the post board. And as a result, any requests for information would be handled as private and or licensing data. One of the other issues is that as we are developing the database that is being worked on to capture this information that CLEOs, chiefs and sheriffs will be required to report as of July 1st. We have to have the knowledge of what we can actually configure the software to collect. And as of right now, the way the statute exists, we would only be able to collect that that public data. And that would basically be the fact that there was a complaint and the officer's name. And that would be the end of it. We would not be able to collect other data. And while I am sure an agency could potentially provide that data, we know based on experience, our agencies that will not share that data, whether it's because of being advised by their legal representation or otherwise, or just choosing not to. And this is an important step in order for us to get this data and use it as it was intended.
Thank you, Director Missel. Representative Frazier, before we go to questions, I note that there are several amendments. Is it your counsel we take the amendments up first and then open up for a broader conversation? Is that a
That's fine, Chair.
Yeah, all right. Very well. Then there is an A1 amendment. And I believe is that your amendment, Representative Frazier?
No, I haven't offered any amendments.
Oh, okay.
That's my amendment. Chair.
Oh, very well. Representative Hollins, and you're wishing to move the A1 amendment?
Yes, Mr. Chair.
Very well.
That is my motion.
Representative Hollins moves to amend House File 1374 with the A1 amendment. Representative Hollins, to your amendment.
Thank you so much, Mr. Chair, and thank you, Representative Frazier, for bringing this important legislation. My amendment is fairly simple. What I would like to do is include probation in the information center and clearinghouse subsection, so subdivision 6. What it does is just include probation and probation terms, condition of probation, just trying to get that probation data included in the data that's collected, as well as there's one note of recidivism, because I think that's a really important aspect of data that we need to collect and understand. Oh, I apologize, my phone is ringing. Of data that we need to collect and understand when making decisions going forward. And so I hope this is viewed as a friendly amendment. I don't think that it is terribly controversial, but that is my motion and my amendment.
Representative Frazier.
I do not see it as controversial, and I do see it as friendly, and I would be willing to accept that friendly amendment.
Very well.
Chair Mariani.
Representative Otney.
Thank you, Chair Mariani. Representative Johnson. Who's up?
I'm hearing another voice.
This is Representative Johnson dealing with the amendment. With this amendment, I understand why this amendment's being offered, but that really has nothing to do with this bill. This is sentencing guidelines, and the bill is talking about post board. With sentencing, probation is part of the sentence, and unfortunately, if we do add this, this is going to have to go to Ways and Means because this is going to add a whole bunch of fiscal costs to sentencing guidelines, which is not in this current bill. I believe we have another bill coming up that sentencing guidelines will be involved with. That this amendment could be looked at that point, because adding this information for sentencing guidelines to do, they're going to have to build programs and all sorts of stuff in order to obtain this information. Unfortunately, they should be doing this already because probation is part of their sentence, but they are not. So I'm going to politely ask that the amendment be withdrawn at this time and be brought up in the proper bill, because I would like to actually get this bill to the floor because I think it's a good bill, some aspects of it, but we were sure to add it on if we want to delay it getting there.
Representative Johnson, I do think your observation about assuming this amendment moves on, going to Ways and Means it makes sense to me. I don't see a conflict in adding this language to the bill. We heard as much from the chief author. It's certainly up to the author to reject the amendment, but I think the motion to amend is appropriate. I think it would probably, to your point, require adjustment of the final motion on the bill. Representative Otney.
Thank you, Chair Mariani. My question is for the author, Representative Frazier. I don't see a breakdown in what data would be transferred to the post board from your bill. So any complaint, any discipline from the way I read it would be related to the post board. And maybe you can clarify, because my concern would be, say, for example, a licensed peace officer in the outstate drives off from the gas pump with the hose in his squad. Therefore ripping the hose out, or say, for example, he or she left their PBT on the hood of their car at a juvenile party and drove off losing a PBT. And in 33 years, maybe that was the only 3 complaints he ever gets in his personnel file. Would that be something that would be reviewed and analyzed by the post board? I'm in Sabika, Minnesota, is that something that, the post board, the post advisory board, that this would be referred to, is that something they're going to be reviewing? Could you clarify that?
Representative Frazier.
Thank you, Mr. Chair. Thank you, Representative Novotny. I've got family in Sabika. So I have to look you up when I'm in town. Those would be some unfortunate situations. I will probably ask for some feedback from Executive Director Missou on this, but the post board would be deciding what information and how they would analyze that information and which information would be pertinent for the system. As ED Missou stated, they're developing this system. So I'm pretty sure they're going to get information from the experts on which data would actually really need to go into the system to help with the early warning system. But I will defer to Mr. Missou if he has anything to add to that.
Director Missou, do you have anything to add to this point?
Yes, thank you, Mr. Chair and Representative Frazier. To your question, Representative Novotny, that is in fact what we are in the process of figuring out right now, actually, is what, as the legislation says, that the post board determines is necessary to do those different things. I did a presentation for the Chiefs Association just the other day, and that is a very good question that came up during that time. And what we'll have to do as we develop this software is define very clearly to the agencies, what constitutes a complaint, what level of complaint should come to the post board. And that's not clear in the legislation, but we have a pretty good idea of where that stands. An example of the where the confusion is that agencies all across the state and really across the nation have different definitions of what constitutes a complaint. There are folks agencies that will consider, say, a verbal discussion or correction on, let's use your example, the PBT on the front of the squad, that somebody finds and tells the agency about it, and they call the officer in and they counsel them. That would not be considered discipline in some agencies. Others might consider that discipline. So we would have to define that, and I grant that that's not entirely clear here. But I think the intent, certainly from my discussions with members of the board, and the intent of the legislation, as I understand it, is that we would want to filter out those. I'll call them minor. I mean, honestly, minor and probably not complaint level kind of stuff that we don't really want to gather. So, but in truthfulness, it is to be determined at this point.
Members, we are on the A1 amendment. Representative Novotny.
Well, just to clarify, I was asking for a friend. None of those examples may or may not have been mine. Representative Frazier, I think those are all things that we should clarify. That I think this should be part of the bill going forward before we just ask the post advisory board to do this for the. So I think I'm going to vote no on this until we get some clarification. I would like to offer to work with you on language on things to get those in, but until we get clarification, I think that I'll be a no, and I would recommend that.
Thank you, Representative Novotny. To the A1 amendment, Representative Raleigh.
Thank you, Chair. No, I'm to the bill once it's into the shape that the author wishes.
Very well. Anyone else on the A1 amendment? Mr. Pinto?
Thank you, Mr. Chair. I just wanted to verify, just kind of process-wise, as I understood, the concern is that potentially the amendment might add a cost to a bill if the bill is policy only. It seems like it could still go to judiciary. I just want to make sure I'm just kind of clear on, and I'm supportive of the amendment, I should note, and supportive of whatever the author wants to do with the bill. I just kind of want to make sure I understood what the situation is.
Yeah, no, good point. It certainly can still go to judiciary, but I do think Representative Johnson made an important point about it at some point, wandering over to Ways and Means, but it could certainly continue on the current track. That will be an appropriate thing to do, to have judiciary look at the policy implications. Obviously, data privacy issue is their jurisdiction.
And just a quick follow-up, Mr. Chair.
Yes, Representative Pinto.
Thank you. So it seems like, I guess I'm understanding correctly, then I guess the question, just to confirm with the bill's author, Representative Frazier, then, is that if the underlying bill does not have a cost currently, potentially this, in my view, really good amendment potentially adds a cost. I suspect it'd be a pretty small cost, if there even is one, which I guess we need to find out. Just want to confirm that he's, supportive of doing this in that way. And again, if he is, I'm certainly supportive of it as well. I just want to make sure I'm clear about what's going on.
Yeah, I do believe Representative Frazier was amenable to accepting the amendment, but Representative Frazier.
Thank you, Mr. Chair. Representative Pinto, I am amenable to the amendment.
Very well. Any further discussion on the A1 amendment? If not, then Representative Hollins renews her motion to adopt the A1 amendment. The clerk will take the roll.
Mariani.
Aye.
Chair Mariani, aye. Vice Chair Frazier.
Aye.
Vice Chair Frazier, aye. Representative Johnson.
Aye. This information should be collected now.
Representative Johnson, aye. Representative Edelson.
Aye.
Representative Edelson, aye. Representative Feist.
Aye.
Representative Feist, aye. Representative Grossel, excused. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hewitt.
Aye.
Representative Hewitt, aye. Representative Cleaborn.
Aye.
Representative Cleaborn, aye. Representative Long.
Aye.
Representative Long, aye. Representative Lucero.
Yes.
Representative Lucero, aye. Representative Mueller.
Mueller votes yes.
Representative Mueller, aye. Representative Novotny.
Novotny, no.
Representative Novotny, nay. Representative O'Neill.
O'Neill votes no.
Representative O'Neill, nay. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Poston. Representative Poston excused. Representative Raleigh.
Raleigh, aye.
Representative Raleigh, aye. Representative Vang.
Aye.
Representative Vang, aye. Representative Xiong.
Aye.
Representative Xiong, aye.
Lucero, yes to no.
That concludes roll call with 14 ayes and 3 nays.
Very well. With 14 ayes and 3 nays, the motion prevails, and House File 1374 is amended with the A1 amendment. There is an A2 amendment. Is someone moving the A2 amendment?
Chair Mariani, that is my amendment.
Representative Johnson moves adoption of the A2 amendment. Representative Johnson, to your motion.
First of all, I misspoke on the last amendment. I have a problem with the bill itself. This is try to fix some of the issues, but the amendment, the A1, I was in favor of, as that information should be collected now so we can get proper information that we need. But I have an issue with the data privacy issue. So this is an amendment to try to clear some of it up. With unauthorized release by a member of the board of or the Ensuring Police Excellence and Improving Community Relation Advisory Council, it releases this private data, it would be a gross misdemeanor. This is very sensitive data that they're collecting, and it needs to be protected. Make sure it's protected extremely well, especially with the some of the citizens on the board might not understand how critical it is and how important Chapter 13 is.
Very well. Representative Johnson, there is an amendment to the amendment. Is that yours as well, or is that someone else?
That is mine as well. And the amendment is in the information being collected. Something that's also very important to understand is who the complainant is on these complaints against officers. I can take an example of a gentleman, a person in my community by the name of Jim. In 1 year alone, he had over 25 complaints against officers. And it was the standing orders that all 4 departments, the State Patrol and the conservation officer in our area would not talk to this gentleman unless we had a tape recorder going, because every time he talked to an officer, he'd file a complaint. And so we never knew what was going on, what he was going to do. I've talked to others officers across the state, and they have individuals in all these areas. Every time they have contact with law enforcement, they always file a complaint. So I think it's important that not only we look at the complaint, the board look at the complaint itself, because all these complaints are going to have to be forwarded to the board and the secondary board. But it's also, I think it's important to understand who's filing the complaints. What's the issue is, if there's a pattern of a person continuously filing the complaints because they have an vendetta against an officer, I think that is also important information. So I'd like this amendment to be added on to the amendment.
Very well. So Representative Johnson is moves to amend the A2 amendment with the A3 amendment. So that's the motion before us, members. Representative Frazier.
So are we, Mr. Chair, thank you. Representative Johnson, thank you. Are we taking an action on the amendment to the amendment, and then we're going to decide if we're going to move forward after that?
Yeah.
With that amendment.
Yes, Representative Frazier, we will take action on the A3 amendment to the amendment, which is an amendment to the amendment. And then we still will need to take action on the underlying amendment.
Okay. I am fine with moving forward to allow Representative Johnson to amend his amendment.
All right, very well. Representative Johnson, voice vote okay?
That would be fine.
Very well. All in favor of the A3 amendment to the A2 amendment, please say aye.
Aye. Aye.
Aye.
Opposed, same sign. Motion prevails, and the A2 amendment is amended with the A3 amendment. I thought I heard something. Okay, perhaps not. All right, so now we have the A2 amendment as amended before us. Representative Frazier.
Yeah, so Representative Johnson, I appreciate you putting this amendment forward. There are parts of it I do agree with, the complaint process with collecting all of that data, but I absolutely think that the post board will be collecting that data. In fact, this gives them the ability, the new language that I hope will go into law will give them the ability to collect that data. If they're collecting complaints, they will get everything that comes along with that complaint. So it would include the individual that filed the complaint, if that exists. I mean, I think that's one of the things we have to think about too. I do believe as we stand today, local law enforcement agencies have the ability to set up their complaint processes, and there may be some that allow it to be done anonymously. So in those cases, it will be pretty difficult for the post board to collect that information if it's an anonymous complaint. But I do think it doesn't prevent the post board from having conversations to identify the particular situation that you just added. I believe the local law enforcement agency will have insight into that, can provide that insight to the post board if it's an individual that is just constantly submitting frivolous complaints, especially if they can do it anonymously and not have any potential accountability or consequences for that. In regards to increasing I am troubled by increasing from a misdemeanor to a gross misdemeanor, because currently now it is a misdemeanor for an individual to violate data privacy under Chapter 13. And most agencies require to do trainings on that. So I am not aware of a rash or a trend where you're having citizens that sit on these advisory boards that are violating the Data Privacy Act, whether there's lawsuits coming or there's been charges of misdemeanors and convictions that are happening. So I don't think that's necessary at this time, because I think there are provisions in place already to address and hold folks accountable. And I think there's tons of training that agencies are required to do to ensure that type of data privacy violation, that those type of data privacy violations actually do not occur.
Well, and Representative Frazier, just to be clear on the record, so the A2 lifts us to a gross misdemeanor. However, currently a violation of 13.08 is also actionable, is it not? Isn't that a misdemeanor?
It's currently a misdemeanor.
Yeah, okay, very well. Director Missel.
Thank you, Mr. Chair. One thing, and I don't know, I get the sense from the conversation, and maybe this has not been discussed, but I know it's something that we looked at when we were considering the legislation and particularly this change. I'm not an attorney, but I would suggest that maybe we should have or it would be prudent to have an attorney weigh in. It's my belief, again, based on my very layman-like position on this, I am not certain that there's anything in either the original reform legislation or in the current legislation that actually would allow the advisory council to have access to that private data. We would certainly share that, obviously, in meeting the need of the statute in terms of providing information for them to do their job, but that would be, I don't see any basis for us to be able to share actually private data with the advisory council. That is only a function of the board, if I'm not mistaken.
Perhaps our council might have some thoughts on this.
Chair Mariani.
I'm sorry, whose voice is that?
Representative Johnson.
Representative Johnson.
The reason I brought this forward is because right in the current statute, it's in the bill as well on 2.12 where it talks about the data. Assist in ensuring police excellent and improving council advisory council in accomplishing their council's duty, which says they can't have access to the data. That's why it's important to follow up on this. And also, the law enforcement world, there's state statutes that make it a higher offense if the officer that was involved is an undercover officer, because the jurisdiction is forbidden by law to release that data. They can't even admit they're an employee with their department.
Very well. I'm wondering if council may have some thoughts to share.
Mr. Chair?
Yes, Mr. Devo, I think you heard perhaps Director Missel's inquiry.
I did, Mr. Chair, and I don't have a direct answer. I think this is certainly something that would be appropriate for the Judiciary Committee, where our data practices expert. This statute was drafted with the idea that it would be public data, so this wasn't a concern when the language was drafted. And as Representative Johnson has noted, the intention was that the data would be shared with the council to help them make their recommendations to the board. So I think this is a technical issue that would need to be sorted out if this language is adopted or considered in a subsequent hearing as to whether there would need to be exceptions to current law with these citizens having access to the data.
Okay, very well, thank you. Representative Otney, I see your hand up. Is it to this amendment or just to the other?
Sir, left over.
Okay, very well. I don't see any further discussion.
Mr. Chair.
Yes, Representative.
If I just could add just a couple of comments to that. I do think currently, and I think Mr. Missel covered some of this, so he alluded to it. Currently, the post board handles private data, and it does not share it with some of the most sensitive data it handles on our peace officers that are submitted to the post board, and it does not share that data with anyone outside the purview that does not that the Chapter 13 would not allow that data to be shared with. I would see this information and to be handled the same way. It still retains the classification as private data, which means the post board will still have to maintain that privacy with that data. And there are ways to share the information that's collected in the database in a summary way where it doesn't de-identify or it doesn't identify the particular peace officer that it relates to. But I agree with what the council said is we can touch on these technical pieces and figure that part out. But I don't think that there would be an issue with having that data maintain its privacy within the database.
Okay, very well. Thank you, Representative Frazier. Representative Johnson renews his motion that the A2 amendment as amended be adopted. The clerk will take the roll on the motion.
Chair Mariani?
No.
Chair Mariani, nay. Vice Chair Frazier?
Nay.
Vice Chair Frazier, nay. Representative Johnson?
Aye.
Representative Johnson, aye. Representative Edelson?
No.
Representative Edelson, nay. Representative Feist?
Nay.
Representative Feist, nay. Representative Grossell, excused. Representative Hollins?
Nay.
Representative Hollins, nay. Representative Hewitt?
Nay.
Representative Hewitt, nay. Representative Cleaborn?
No.
Representative Cleaborn, nay. Representative Long?
No.
Representative Long, nay. Representative Lucero? Representative Mueller?
Mueller votes yes.
Representative Mueller, aye. Representative Novotny?
Novotny, aye.
Representative Novotny, aye. Representative O'Neill?
O'Neill, aye.
Representative O'Neill, aye. Representative Pinto?
No.
Representative Pinto, nay. Representative Poston?
Aye.
Representative Poston, aye. Representative Raleigh?
Raleigh, aye.
Representative Raleigh, aye. Representative Vang?
No.
Representative Vang, nay. Representative Xiong?
No.
Representative Xiong, nay. Representative Lucero? That concludes roll call with 6 ayes and 11 nays.
Very well, with 6 ayes and 11 nays, the motion does not prevail. And members, I do appreciate the discussion and debate, and Representative Frazier, I certainly suspect you'll have this further vetting of this issue in the next committee, assuming the bill moves on to judiciary. Representative Frazier, you get the last, oh, wait a minute. Is there any other comments on the bill? Representative Raleigh.
Thank you, Chair. Now is when I want to ask the question. So specifically to Director Missile, he stated, I've got a couple questions along this line. He stated that we're not able to collect other data. Would the director please give us an idea of the other data that you had, that you were thinking of when talking about other data that's not being able to be collected? Because it sounded like you were referring to things that you'd like to see. I'd like to know what other types of data you were thinking of.
Director Missile.
Thank you, Mr. Chair, and thank you for the question, Representative Raleigh. What basically the information that would allow us to get this job done, and it goes actually to a lot of the discussion that was already has already been had in terms of it. And again, I'm not going to weigh in on the complainant, the name of the complainant piece, but for example, you know, the date, the time the complaint came in, the very general information that currently is classified, well, and would continue to be classified as private. So the way the statute's written, we'd only collect public, and Data Practices Office will tell us that the only thing that's public when a complaint comes in is the existence of that complaint and its current disposition. That's it. And actually for us, the AG's office has advised us, and there's a little bit of a conflict between the two there, that even the existence of a complaint is not public. So that without the change, then those agencies would be able to withhold all of that information, even the basics of the date it occurred and what was the nature of the complaint and that sort of thing. And obviously that's critical to us being able to carry out the purpose of the legislation.
Representative Raleigh.
Thank you, Mr. Chair. And one of the classifications that was talked about in the testimony today was the way and the method that the complaints are coming in. And so I've got two questions on how the complaints are coming in. The first one is we're seeing, we live in a world now that is based off of instant information gratification. I have the ability to tweet or post or fill out forms. In fact, I have the ability to write scripts that can go against complaint forms, and I could flood you with what's called a distributed denial of service attack. How are we going to protect against a campaign of complaints against an officer with the technology that we have nowadays and our desire for more transparency and more openness about the types and nature of the complaints that are coming in? How are we, the first part of the question is, how are we going to protect against the nature of automated complaint bots coming in?
And Director Missile, I think this gets at the issue of how the Post would receive that information in the first place, because you're not, I believe, the original, point of which that comes in. But Director Missile.
So with regard to the database itself, I think it's important to remember that this is not a public-facing database. There is no public access to that database. This comes from the law enforcement agencies themselves. So that's that's the only way it's coming in. And that's required for any number of reasons. Obviously, the security is first and foremost, to make sure everything's encrypted and protected. And talking with the IT folks, this is absolutely not the kind of database that can have a public face. To your question, I would say that further down the road, you know, if we were to, as the post board as an example, just like a law enforcement agency, you know, allow online complaints from citizenry to come in, I'm probably out of my depth in commenting on how we would weed through a sustained campaign where you get thousands and thousands. I know that our board members receive thousands and thousands, literally, of emails post George Floyd incident, and you know, I don't know that I'm in a place to say how to best manage it. I think we just kind of muddled through it. But in terms of the database and this particular, what the subject of the bill, this complaint database, this complaint information that's coming in, that's exclusively through the law enforcement agencies and is not a public facing website or interface.
Representative Raleigh.
Thank you, Mr. Chair. And the second part of that question is, once data is in this database, and in the very limited amount of data that's going to be in there, as you've discussed and testified so far, is the outcome of any investigations attached to the complaint? And how is the, and let's pick two outcomes. One is investigated and found that the police officer had done what it was complained against. And in another one, it was found to be, let's say, exonerated. It might be one of the terms that are used. How are those two complaints, and let's say they're the exact same complaints, and one of them is exonerated, the other one is justified or found, I don't want to use the word guilty because I don't know if that's the right word, but
Sustained.
Sustained. Do you understand the direction of the question?
Yes, sir.
Thank you.
So yes, so all of this data, and that's really the point, at least as I see it, this is my take on it. The point of this database and the point of the software is that it will capture all of that information, whether the complaint's sustained, exonerated, not sustained, you know, there's any number, and that's what we have to build into the system. So to your point, and this came up during my presentation to the chiefs the other day, this will be in my mind, if it works the way it's intended to, will actually should give us some really good data, and will allow us to report out the percentage of complaints that come in, and of that, you know, that are sustained or that are exonerated or found, you know, not to be to have any validity or to be completely valid. Not only that, because there'll be dispositions and other information that comes in there. If it's handled at the agency level, let's say in the case of a sustained complaint, and the agency meets out XYZ discipline, whatever that is, we would have a record of that. And honestly, if it doesn't fall within post-board jurisdiction or doesn't rise to the level of a violation of our standards of conduct more broadly, that's the end of it. But there's at least a record that there was action taken. And the same for complaints that are not sustained or are, you know, found to be exonerated. Just to add a little bit depth to it, one of the questions from the chiefs was, so if you have an officer, and this may go to Representative Johnson's commentary, you know, more broadly about a complainant that complains about everything. If you have an officer that's in the database and they have multiple complaints against them, however, those complaints have been looked into, you know, they're listed all as not sustained. It's really for the chief or for the post board at that point to look into it. And if it turns out that, hey, this is an officer that's extremely active, they work the night shift, and by nature of that, they get complaints, but everything has been looked into and we're good, then that's the end of it. But the point is that we can at least capture that data, know it's there, it's reviewed, and then properly dealt with.
All right, members, let's move toward a vote. Representative Raleigh, I still have two other bills before me.
Yes, Mr. Chair. In the interest of time, I will pull back my last question. Thank you, Mr. Chair.
Very good questions, Representative Rowley. All right, numbers then. Representative Poston, I see your hand is up.
Thank you, Mr. Chair. I appreciate it. Representative Frazier, I had to jump on this call a little bit late, so I apologize if you've already answered this question. I was in another committee. Can you just tell us where this is in the Senate? Is this moving forward in the Senate? I didn't see a companion.
Representative Frazier, quickly.
It is in transit to the Senate to an author to be moving in the Senate, Mr. Bolson.
Okay.
So thank you for jumping back on. I did see you voted against that amendment, so I assumed you were on.
Yeah,
Thanks for coming back.
Thank you, Representative. Appreciate it.
Thank you. Representative Frazier renews his motion that House File 1374 as amended be referred to the Judiciary Committee. The clerk will take the roll.
Mariani.
Aye.
Chair Mariani, aye. Vice Chair Frazier.
Aye.
Vice Chair Frazier, aye. Representative Johnson.
No.
Representative Johnson, nay. Representative Edelson.
Aye.
Representative Edelson, aye. Representative Feist.
Aye.
Representative Feist, aye. Representative Grossell, excused. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hewitt.
Aye.
Representative Hewitt, aye. Representative Cleaborn.
Aye.
Representative Cleaborn, aye. Representative Long.
Aye.
Representative Long, aye. Representative Lucero.
No.
Representative Lucero, nay. Representative Mueller.
Mueller votes no.
Representative Mueller, nay. Representative Novotny.
Novotny, nay.
Representative Novotny, nay. Representative O'Neill.
O'Neill, no.
Representative O'Neill, nay. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Poston.
No.
Representative Poston, nay. Representative Raleigh.
Raleigh, nay.
Representative Raleigh, nay. Representative Vang.
Aye.
Representative Vang, aye. Representative Xiong.
Aye.
Representative Xiong, aye. That concludes roll call with 11 ayes and 7 nays.
Very well. With 11 ayes and 7 nays, the motion prevails and House File 1374 as amended is referred to the Committee on Judiciary. Thank you, Representative Frazier, Director Bissell, and Dr. Erickson. Members, the next two bills, I'm thinking we can do relatively quickly. Representative Xiong has House File 1442, and Representative Xiong moves to refer House File 1442 to the General Register. Representative Xiong, if you can tell us very quickly what this is, and then you've got a couple of testifiers that could fill in as well.
Thank you, Chair Mariani.
And I'm sorry, Representative Xiong, let me correct the motion. You know, I was thinking J and I just now saw the T. You're not a member of this committee, so you can't make motions. My apologies to you, sir. The chair moves to refer House File 1442 to the General Register. Representative Xiong.
Thank you, Chair. This proposal updates the Minnesota Code of Military Justice and related statutes to better reflect the changes in 2019 to correspond, with the federal laws and to remediate potential weaknesses in our existing court martial process. And I'll leave it up to the testifiers to go over some of the main purposes of the changes that were being made. And I have here Don, the Executive Director, Don Kerr, and Lieutenant Colonel Blomgren.
Very well. Welcome to the committee, Executive Director Kerr and Lieutenant Colonel Blomgren. We'll start with you, Executive Director, and let me apologize ahead of time because I'm going to rush you just so to make sure that we don't run out of time. So if you can be as brief as possible, I'd be greatly appreciated. Mr. Kerr, welcome to the committee. State your name for the record. Give us your testimony.
Thank you, Mr. Chair and committee members. My name is Don Kerr. I'm the Executive Director of the Minnesota Department of Military Affairs. My remarks will be very brief. This is an agency bill, and we'll have Colonel Blomgren do the detailed explanation of it, if you don't mind, Mr. Chair.
Super. Thank you, Mr. Kerr. Lieutenant Colonel Blomgren, welcome to the committee, sir.
Mr. Chair, committee members, for the record, I am Lieutenant Colonel David Blomgren and serve as the General Counsel for the Minnesota National Guard and Department of Military Affairs, where I serve as a full-time legal advisor to the Adjutant General and other senior staff. I assumed this role in 2018 after spending 11 years on active duty in the Air Force. First, let me thank you for inviting me to testify this afternoon in support of this bill. Compared to the active duty force, our military justice structure is quite different, given the fact that most of our members are not on a duty status most days of the month. While we currently have the legal ability on paper to conduct a court-martial, there are gaps that would make it legally impractical to conduct one now. This bill will fill those gaps and in turn will provide that additional legal tool in the commander's toolbox to ensure good order and discipline in the Minnesota National Guard. One of the gaps we've experienced in the National Guard is the inability of out-of-state attorneys to provide military legal advice without having to go through the pro hoc vice process. This bill would allow for out-of-state licensed attorneys to provide military defense services or serve as a military judge, provided that they are otherwise qualified for such duty by the Judge Advocate General of their service and are a member of another state's bar. This is consistent with how the JAG Corps operates on the federal level. While we typically are able to utilize Minnesota licensed attorneys, there are times when we need to go out of state, particularly when senior level members are under investigation. This change has been socialized with the Minnesota Office of Lawyer Registration and the Office of Professional Responsibility, and they concur with the change. The second gap this bill fills is the legal authority to receive law enforcement data on Minnesota National Guard members when they are investigated by local law enforcement. In most cases, when local law enforcement investigate a crime and their prosecutor determines that there is not enough evidence to pursue criminal charges, we still have the ability to pursue administrative action or pursue a court-martial. 9 times out of 10, local jurisdiction does provide us the relevant investigation so that we can take that action. However, some jurisdictions currently do not. This simply adds to the time it takes to investigate wrongdoings, since we then have to do our own investigation, particularly when it comes to cases of sexual assault. This bill also fills a number of jurisdictional gaps or ambiguities that currently exist on paper. Specifically, it clarifies when members are subject to the Minnesota Code of Military Justice, clarifies which crimes are considered military-specific crimes and therefore give the Minnesota National Guard primary jurisdiction, and clarifies the maximum punishment for the punitive articles of the code. It also specifies that the Bureau of Criminal Apprehension is the investigative arm for the Minnesota National Guard for military-specific crimes. The fourth gap this bill fills is the appellate process for court-martial. Currently, it is unclear how a defendant or the government would appeal a court-martial proceeding. The changes clarify when the appeal period starts to run and clarifies that the appropriate appellate authority is the Minnesota Supreme Court. The changes have been reviewed and concurred by the Minnesota Attorney General's Appellate Division. And finally, this bill aligns the Minnesota Code of Military Justice with updates to the Federal Uniform Code of Military Justice with respect to newly added punitive articles. Specifically, it adds the following offenses to the Minnesota Code: recruiter misconduct, non-consensual distribution of intimate images, fraudulent use of credit cards, and unauthorized use of a government computer, and finally, retaliation. Again, I thank you for the opportunity to testify today, and I'm happy to answer any questions that you may have.
Very well, Lieutenant Colonel, I appreciate your testimony. Representative Xiong, I understand you've already been to judiciary, and so they've had a vetting of it there. Members, questions, comments? Very well, then if not, the chair renews his motion that House File 1442 be referred to the General Registry. The clerk will take the roll.
Chair Mariani.
Aye.
Chair Mariani, aye. Vice Chair Frazier.
Aye.
Vice Chair Frazier, aye. Representative Johnson.
Aye.
Representative Johnson, aye. Representative Edelson.
Aye.
Representative Edelson, aye. Representative Feist.
Aye.
Representative Feist, aye. Representative Grosso, excused. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hewitt.
Aye.
Representative Hewitt, aye. Representative Cleburne.
Aye.
Representative Cleavorn, aye. Representative Long.
Aye.
Representative Long, aye. Representative Lucero.
Yes.
Representative Lucero, aye. Representative Mueller.
Mueller votes yes.
Representative Mueller, aye. Representative Novotny.
Novotny, aye.
Representative Novotny, aye. Representative O'Neill.
O'Neill, aye.
Representative O'Neill, aye. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Poston.
Aye.
Representative Poston, aye. Representative Raleigh.
Ollie, aye.
Representative Raleigh, aye. Representative Vang.
Aye.
Representative Vang, aye. Representative Xiong.
Aye.
Representative Xiong, aye. That concludes roll call with 18 ayes and 0 nays.
Very well. With 18 ayes and 0 nays, the motion prevails. And House File 1442 is referred to the General Register. Thank you, Representative Xiong. Good to have you in our committee. Thank you, Lieutenant Colonel Blomgren, for your very concise testimony and also for your service to our state and our nation. And Second Director Kerr, always good to see you. So thank you as well. With that, members, our final bill is House File 1562. This is Representative Hansen's bill, and the chair will move to refer House File 1562 to the Ways and Means Committee. Representative Hansen, your bill is before us.
Thank you, Mr. Chair and members of the committee. House File 1562 is the DNR policy bill, and it is making a stop here in this committee because of Section 5 relating to a person may not shoot at a decoy of a wild animal that is placed by a licensed peace officer. And I have Colonel Rodman Smith here to talk about this anti-poaching provision.
Very well. Welcome back to the committee. Colonel Smith, please state your name for the record and give us your testimony.
Colonel Rodman Smith, Director of Enforcement, Department of Natural Resources. Mr. Chair and members, I'd like to thank Representative Hansen for carrying this bill. What Section 5 does is it really helps with private landowners that have issues with people poaching on their property. And so unfortunately, due to drafting, you can't see that in subdivision 1 of that same statute, it's illegal to shoot at a big game or a decoy placed by a conservation officer from a road or a road right of way. What we're changing in Section 2, make sure that it's illegal to shoot from a motor vehicle at a decoy placed by a conservation officer. So what that change does is if somebody's driving along and they turn off the road and go into a farmer's back 40 off the road, they're no longer in the road or road right away, but they're still shooting from a motor vehicle. And so it's a very purposeful criminal act, shooting at a decoy placed by a licensed peace officer, and we appreciate your support on this.
Terrific. Thank you, Colonel Smith. Are there any questions or comments? I'm not seeing any. Representative, wait a minute. I knew if I hung in there long enough, I would encourage Representative Raleigh to ask a question. Representative Raleigh.
Yeah, sorry about that. It took a minute to try to find that stupid button. Thank you, Mr. Chair. Is it the intent, as I read the bill, it says motor vehicle, would that include watercraft?
Oh, very good. Colonel Smith.
Mr. Chair, Representative Raleigh, let me see, let me just pull up the language here, make sure I got it.
We can also get legal counsel to help us with this as well.
Yeah. Mr. Chair, Representative Raleigh, yes, it would, but a boat in 86B is not considered a motor vehicle unless it's under power. So if it's adrift or anchored, it wouldn't be considered a motor vehicle. So if somebody did shoot at a decoy placed by a wild animal, the motor vehicle, the boat would have to be under power. And so there's other issues with that as well. So it would fit in this, yes.
Representative Hansen, you might have an issue with your bill here, man.
It can get resolved.
I'm just thinking about someone just sort of floating down the river somewhere. And
well, Mr. Chair, just to clarify, so if the boat is under power, so if the boat's running and it's running, then yes, it would be illegal to shoot at a decoy.
placed by a conservation officer. But there's other issues with that as well. You can't have a loaded uncased firearm when the boat's under power and all that other stuff. So it really doesn't change anything, Mr. Chair.
Good point. Thank you. Representative Raleigh.
Thank you, Mr. Chair. And would the chair entertain us asking any questions about the color pink?
Oh, you got me intrigued now.
Mr. Chair, I would like to hand this off to Lee Johnson.
Oh boy, wait a minute. Let me put on my shades and then all right, Representative Johnson.
Chair Mariani, Representative Hansen, I do have one question for you. I know when I was talking to my the GOP lead in that committee, and they didn't have any problems with the bill until there was amendments put on it. And it changed from a supporting to the entire GOP side against this bill. Can you tell me what happened in that committee?
Representative Hansen, Chair Hansen.
Thank you, Mr. Chair. And I think this provision is probably not the provision that's in front of this committee. It was discussed in the other committee, and that's relating to blaze pink. The DNR policy bill had a provision for ground blinds to allow blaze orange and blaze pink. And I don't know, Representative Johnson, if you were here during the blaze pink discussions that occurred over probably 2 or 3 legislative sessions. I know the chair was, and I'm sure he remembers those fondly. But there was testimony on the House floor by some of our colleagues who are colorblind that cannot see pink.
Yes, indeed.
And that safe pink is a safety issue. And so the DNR was adding that it would be pink would be allowable on ground blinds. The majority on our committee did not support that, and also felt that the safety issue of pink in general as a alternative to blaze orange should be removed, that we should go back to blaze orange because of the safety provisions.
Representative Johnson.
Chair Mariani, Representative Hansen, I know the biggest issue was not the blaze pink. It is an issue for me because that was actually my bill last session. As you can see by my background right now, if you have the cameras on, blaze pink, especially at dawn and dusk, is much more visible. The blaze orange, after a year or two, if you don't replace it every 2 years, looks brown at dawn and dusk. That's a serious safety issue. I've seen the blaze pink in the brush where I couldn't see the person standing next to them in blaze orange. Blaze pink overall is much safer. That's one issue. But the other issue is the fact that banning the lead shot in the wildlife management areas. I think that was another issue that was brought up some issues. So it makes it difficult for us, for my side of the aisle, to even vote for this. I am glad that you're putting the at least the orange requirement on the ground blinds. That was a bill I had last session also. I hadn't got around, unfortunately, been so busy, hadn't got around to getting the bill rejacketed, but I'm glad it's in the bill because that is important. Because I've stood 25 yards from a ground blind and not been able to see it. And there was a person in that blind at that time. So it's very important to have that. But unfortunately, with those 2 provisions that were amended on in the Environment and Natural Resources Committee, I cannot have my members support this bill. Thank you.
Thank you, Representative Johnson. We have one final question, Representative Lucero. Members, this is a bill that encompasses many sections and almost makes me wish that I was on Chair Hansen's committee just to get into these debates. However, we are focused on the decoy shooting issue from motor vehicles prohibited. Representative Lucero.
Mr. Chair, thank you. I don't have a question. I just wanted to say I'm a big fan of pink, whether it be blaze pink, whether it be pastel pink, whatever it is. Thank you, Mr. Chair.
I like pastel pink. Looks good. Chair Johnson, final thoughts? I'm sorry.
Aye.
Chair Hansen.
Oh, Chair.
Oh, Lordy, you guys got me today. Chair Hansen.
I'd appreciate your support. I understand that people have concerns with other provisions in those. I'm sure we will talk about those on the House floor, but I think the decoy provision that's in front of your committee is really important. So I'd ask for your support.
I concur. Thank you, Representative Chair Hansen. The chair then reduces motion to refer House File 1562 to the Ways and Means Committee. The clerk will take the roll.
Chair Mariani.
Aye.
Chair Mariani, aye. Vice Chair Frazier.
Aye.
Vice Chair Frazier, aye. Representative Johnson.
No.
Representative Johnson, nay. Representative Edelson.
Aye.
Representative Edelson, aye. Representative Feist.
Aye.
Representative Feist, aye. Representative Grossel, excused. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hewitt.
Aye.
Representative Hewitt, aye. Representative Cleaborn.
Aye.
Representative Cleaborn, aye. Representative Long.
Aye.
Representative Long, aye. Representative Lucero.
No.
Representative Lucero, nay. Yeah. Representative Lucero, nay. Representative Mueller.
Mueller votes no.
Representative Mueller, nay. Representative Novotny.
Novotny, no.
Representative Novotny, nay. Representative O'Neill.
O'Neill, aye.
Representative O'Neill, aye. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Poston.
No.
Representative Poston, nay. Representative Raleigh.
Raleigh, nay.
Representative Raleigh, nay. Representative Vang.
Aye.
Representative Vang, aye. Representative Xiong.
Aye.
Representative Xiong, aye. That concludes roll call with 12 ayes and 6 nays.
Okay, with 12 ayes and 6 nays, the motion prevails. And House File 1562 is referred to the Committee on Ways and Means. Thank you, Chair Hansen, and thank you, Colonel Smith, for being with us here today. Members, that concludes our business for the day with 2 minutes to spare. Well done, everyone. Don't spend all that time in one place now. We will reconvene tomorrow at our regular time. And so until then, this committee stands adjourned.